bond on these. So that means if they release you and you don't come in here, now you violated my bond. Understood? Or if you get into new charges after you get out of there. So raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Counsel, is that all clear enough?
It is, Judge. I was going to ask the court to keep her on and have fun, so she'd be approving credits concurrent, but I understand the court.
I don't want her to. Because if I'm going to send her to treatment, I want to hammer over your head to make sure you're going to treatment.
Understood, Judge.
Normally I'm pretty good about that stuff. The other thing is we've got a file here that you owe us money on from 2015. I'm closing that and giving you some Oakland County jail time credit and just close it out. All right? I'm giving you a lot of grace today. So seriously.
6 months in the county jail as part of this disposition so that it doesn't
Like jail at all.
Oh, okay.
I'd rather have her in treatment programs.
Yeah, and that's what she wants.
How do we
can't get out until May?
I'll see some of it.
So she won't get out until May, but she can
Schedule
program
sentencing in May.
in May. Okay. That's fine.
I defer.
You don't care when I sentence.
I defer to you. You know,
No, I'd rather get her out of, where's she at?
She's she's here, but
No, I mean-
she's serving for Oakland County.
I'd rather get her out of, get that done and come in here and let's get her in a treatment program. That'll give you a lot of time to figure a program out.
Fine. Yeah, that works. Perfect.
All right, People versus Parks, appearances, please.
good afternoon, Your Honor. Mohammed, I'm head of people P86771.
Good afternoon, Your Honor. Neighborhood Defender Service by Jonathan Cohen, D86151, appearing on behalf of Ms. Ryan Parks, present in custody. Can you figure it in?
Brian Burns.
Thank you. All right, guys, put the deal on the record.
So, Judge, my understanding based off of my discussions with the OIC and the officers involved is they approved the plea in this case, which is reducing the both possession counts to use and the receiving concealing would be reduced to joyriding attempt.
Attempt joyriding, right? Correct, counsel?
That's correct, Your Honor. And that's our understanding that each of those would be a 1 year maximum in 2 years.
All right, Ms. Parks, do you understand your rights and options after discussing those with counsel? You understand the possible penalty for these 3 charges? Understanding all of that, are you pleading guilty freely and voluntarily today to the added charges? Counsel, would you voir dire and get me the facts I need for a November 21, 23 incident date?
Yes, November 21, 2023, Ms. Parks, were you, grab my.
What do you want to know? Location? Van Buren Township.
Yeah, were you located at approximately 915 Belleville in Van Buren Township? Were you in possession of a vehicle at that time? Did that vehicle belong to you? Did you take that vehicle without authority from the owner?
Yes.
But did you intend to return the vehicle?
Yeah.
Did you also use on that date time fentanyl? Did you also use cocaine?
Gentlemen, you satisfied? So am I. I'll dismiss the original counts 1, 2, and 3. So do you have an actual out date from Oakland yet?
May 5th.
May 5th? Are you in any kind of a treatment program now? There?
And a
All right. All right, so here's what I'm going to do. I've accepted your plea on these charges. I'm just making a note in the file. We're going to sentence you after May 5. So keep in contact with him. If you get out early or something like that, get a hold of him. He'll get you in here so I can sentence you. He's going to work on a treatment program because I want you in treatment. I don't want to put you in jail yet. I want you in treatment. All right. So in the meantime, I'll put you on a personal bond on these. So that means if they release you and you don't come in here, now you violated my bond. Understood? Or if you get into new charges after you get out of there. So raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Counsel, is that all clear enough?
It is, Judge. I was going to ask the court to keep her on and have fun, so she'd be approving credits concurrent, but I understand the court.
I don't want her to.
I understand.
Because if I'm going to send her to treatment, I want to hammer over your head to make sure you're going to treatment.
Understood, Judge.
Normally I'm pretty good about that stuff. The other thing is we've got a file here that you owe us money on from 2015. I'm closing that and giving you some Oakland County jail time credit and just close it out. All right? I'm giving you a lot of grace today. So seriously,
Um.
Judge, we have discussed this at length, and as I previously indicated, we have some preliminary matters that we need to work.
what are they?
So, Your Honor, I guess some things, but first is that, I have requested of the people, to provide what I would call a statement that was made by the complainant, about this case. I believe it's a signed statement, it's a signed written statement, and I believe it to be potentially exculpatory and also certainly useful for impeachment. It's my understanding that the people the people as a whole are refusing to do that. So that's the first issue, right?
Well, let's take them one at a time.
It's kind of tied together. I am also asking the court to consider adjourning this matter because it's my understanding that either way the people intend to proceed via hearsay, via the domestic violence hearsay rule. I did not anticipate that in any way in this case, and I would ask the court, in addition with the issue of the statement, I would ask the court to consider a brief adjournment of the matter. There are some issues that, as we move forward, I would like to address as it relates to bond, as it relates to that as well.
All right. Why would you not want him to have the statement?
Judge, maybe approach,
Well, better question. Why would he not be entitled to the statement?
Judge, maybe approach,
Sure.
and then we'll make a record of conversation.
Oh, 1,000. Go around.
And can I request a protective order for it?
Sure.
Okay.
Yeah.
Awesome.
All right. So we're back on the record with the Talus matter. I have reviewed the report in question, and I do believe it's something that defense should be entitled to, and I will order release to Mr. Bickert with a protective order. So it's for Mr. Bickert's eyes and Mr. Talus's eyes only. Agreed?
Yes, thank you, Your Honor.
Any more clarification necessary?
No, Your Honor.
Not as to that issue.
All right. Now, as to the adjournment.
As to the adjournment, I'm asking the court to consider an adjournment. I was not aware of this statement, so today.
That's problematic.
Asking the court to consider a brief adjournment and prepare for the exam.
I have no objection.
I do. I hate adjournments. December 23, December 30, or January 8.
I asked for the soonest possible day, Your Honor, which leads kind of into the next.
That's December 23. What time, Heather? 1 o'clock, December 23.
That's fine.
I'm sorry, December 23rd,
Yep,
which is a Monday?
yep. Unless you want to be here on 25th, which my family would not appreciate it.
Yeah, I'm that's what hesitation on is. I think my family might appreciate the 23rd. But I will take
It's your option, 23rd or 30th.
both there, figure it out.
All right, so we're going to talk bond next.
Yes, Your Honor.
I believe the bond is 20,000 personal, cannot return to the Houston address, no contact with Erica Buchanan, and no alcohol or drugs. Are we all on the same page with what the current conditions are?
Yes, sir.
Go ahead.
Your Honor, we're not asking for, a change in any of those numbers or anything. What the situation is, and I apologize, Your Honor, I know that Mr. Talus is not at his home because of the no contact. It is my understanding, I believe there's some corroboration of that, is that, this is kind of a difficult situation, but there's another person, there's a break-in, in essence, or at least a destruction of property.
I wouldn't say break-in. I think the
That's fine.
allegation was brick was possibly over.
Okay.
Oh, and that's why I was changed, or possibly a malicious destruction situation. Either way, a window was broken out at my client's home. I don't know who it was, I don't know who it was there, et cetera, et cetera. He has no contact, his children at the home. Brick was.
Bonds 5960. I represent Mr. Disney and we are ready to have a preliminary examination. Obviously, I have no objection to the OIC hanging out, testifying, or whatever makes him comfortable on this.
Okay.
Maybe fall after him.
Judge, is a preliminary matter of requesting mutual order of sequestration.
Granted, sir, you can have a seat. How's it going? Excellent. Can we get going, guys?
I have a stipulation with defense counsel.
Love stipulations. Go ahead. I said love stipulations. Go ahead.
We
stipulated it's late.
to the defendant's prior conviction, specifically the 2023 delivery charge.
Okay,
He's right. I did tell him I would do that.
thank you. Anything else?
First witness is Officer Gasnow.
Did you catch that, Ken?
Gasnow? Yes. Thank you.
Do they call him Casanova?
He did in his younger days. He was really his thing. How did you get what you did?
No, it's in there.
Officer, come on up front. Raise your right hand as you're walking up here. Swear, affirm, tell the truth, the whole truth, nothing but the truth today. Watch your step on my ramp right here and settle yourself in that chair. After you're settled in, state your name, spell your last name for Heather, please.
Val Casno, spelled AYLEKASENOW.
Say it again.
Kyle Casno,
Casno?
Casno.
Casno. Like Cas, no. Got it. Thank you.
Thank you. Good afternoon, Officer Gasnow. Are you currently?
Casno.
Gasnow, my apologies. Officer Gasnow, are you currently employed?
Yes.
Who is your employer?
In your township, police department,
Okay, and in what capacity are you employed there?
police officer.
Okay, and were you employed in that capacity on September 17th, 2024?
Yes.
Okay, did you work that date?
Yes.
Did you work that date by yourself or with a partner?
I was with myself in the vehicle, but I had other officers.
Okay, and on that day of September 17th, 2024, did your duty take you at or near the location of 44911 Ecorse Road?
Yes.
Okay, is that located in the city of Van Buren Township,
Yes.
County of Wayne?
Yes.
Okay, and what took you to that location?
Dispatch call for a domestic violence complaint.
Okay, and what did you do when you made that location?
As I was approaching the location, I was met with victims. When I stepped on my vehicle, I spoke with them.
Okay, and do you recall what the name of the victims were?
Yes. Benny and Michelle.
Okay, and do you recall, did you learn as part of your investigation why they were at that location?
Yes, they're residents of the location.
Okay, and did you locate a defendant shortly after at that location? And did you learn what that individual's reason for being at that location was?
That's what I was at the location.
Okay, and you have a discussion with Michelle Disney and Benny Disney?
Correct.
Okay, and what was the discussion with Michelle?
The chair should adhere say if he's asking for it, shall say.
The judge, pursuant to the rules of 768.27C, using the DB exception, which will let an officer testify to hearsay statements when the case stems out of a domestic violence case.
Mr. Jones.
We just want the record to reflect.
That's, you don't have to jump, Mr. Jones.
I just want the record to reflect that the two complaining witnesses were subpoenaed here last week as well, chose not to show up. Can we stipulate that?
Correct, I won't read Judge,
And with that, I accept what I anticipate will be your ruling on the issue, because I know not to argue with you when you rule on such issues.
Thank you, and I will allow it.
thank you. And what was that discussion with Michelle?
She advised me that she was hit in the face by her son.
Okay, so how did that begin? What did she tell you from the beginning?
So when I pulled up on scene, there was blood coming from their face, both of them. I asked them where it came from. They said that they were struck in the face. She advised me that she was struck approximately 4 times. Then Benny advised me she was struck in the face approximately 1 time.
Okay, did she,
Just so the record's clean, and we can make a record, I object to what Benny said. It's in your line.
well, Judge, again, it's pursuant to the DB exception, 768.27C.
And I'll allow it.
Stipulation that Benny was
Yep.
supposed to be here today, and last week, and he's not, but, is it correct?
Correct, the victims were both subpoenaed to appear here today and have both failed to appear But their statements to the police officer would be coming in through 7/6.
And I'll allow it. And I'll also let Mr. Jones make his record.
Understood.
Okay, go ahead.
And did the discussion with the victim, Michelle, did you learn how this began?
Yeah, it began, they were woken up, from their son, wrecking a shotgun in their kitchen.
Did you learn where they were?
They were in their bedroom.
Look, I'm sorry. They being Benny and Michelle?
Benny and Michelle.
Thank you.
Thank you. Yeah, thank you for your time. Okay, and what happened?
They stated, Benny and Michelle stated to me, that their son David entered the room, turned on the lights, they began arguing. After they began arguing, he pulled the blankets and the pillow away from Michelle. After this proceeded, David entered and, pushed Michelle onto the ground. After pushing Michelle onto the ground, David got on top of Michelle and put his forearm to her neck area, where she stated to me that she was having difficulty breathing.
Okay, now, do you recall did she ever advise you what initially woke her up?
She advised to me that, the wrecking of the shotgun was what initially woke her up.
Okay, and then was it shortly after that, is that when the defendant entered the room, turned on the lights?
Correct.
Okay, and
Well, Judge, I'm gonna object to that because I presume the officer wasn't there. So he probably has no personal knowledge. Alternatively, if he were asked, then you would continue to allow the exception to hearsay, we're in a different place, but I gotta try and keep it on the same line.
Yeah, let's make sure that at this point he's testifying as to what he was told by Michelle.
correct. Did Michelle tell you, what woke her up?
She did.
What did she tell you woke her up?
Michelle told me that the shotgun being wrapped was what woke her up.
Okay, and did she tell you, how she felt when she was being, was she being choked? Is that what you said? The forearm was at her neck? Is that what she told you?
Correct.
Okay, did she tell you whether or not she passed out?
She did say that she did not lose consciousness.
Okay, did she tell you, how long the forearm was at her neck?
I do not recall.
Okay, did she tell you whether or not she had trouble breathing?
She did mention that she had
What did she say exactly?
That she had trouble breathing.
Okay,
I heard that one.
okay, and what else did she tell you, if anything?
Michelle mentioned, what happened after that with Benny grabbing a stick. And
Okay.
then he struck David in the head, approximately 7 to 8 times.
Okay, and did Benny tell you why he struck the defendant?
Benny mentioned that he was trying to get David off of Michelle.
Okay, and did Benny or Michelle tell you of any statements that the defendant made during this interaction?
Benny and Michelle mentioned that, David was stating that he was gonna hurt them, harm them, kill them.
Okay. Did Benny or Michelle ever tell you how they felt during this interaction?
Yes, Benny and Michelle both mentioned that they were feared for their life.
And did you observe the victims at this?
Yes.
Okay.
Let the record reflect he showed me the pictures that he wants to admit into evidence.
Thank you. Almost out there witnesses on this.
Go ahead. Sure, make that 3 pictures.
Thank you. Wipe that smile off your face. Mohammed, wipe that smile off your face.
I'm sorry?
Wipe that smile off your face.
Oh, yeah, it's hard. Officer, I've handed you what's been marked as People's Proposed Exhibit number 1. You recognize it?
Yes.
Okay, now how do you recognize that?
I recognize the, defendant's head.
Okay, and who is, okay, so who is that in the people's proposed exhibit number 1?
That's Ben, busy.
Okay, and how do you recognize him?
From the scene.
Okay, and was that how he appeared at the scene?
Correct.
Okay, and to the best of your recollection, does that appear to be a fair and accurate representation of the individual Benny, the victim that you observed on the scene?
Correct.
Okay, does that photo appear to be altered or manipulated in any way?
No.
Judge, I'll move into evidence, proposed exhibit number 1.
I'll stipulate to it.
Thank you. Appreciate that.
That goes to the other two as well, whichever.
That's helpful. Thank you.
Judge, I'd like,
I learned from watching you.
Judge, I'd like to publish to the court.
Thank you.
Okay, and you learned anything else from what the victims told you?
Benny and Shell both mentioned to me, that after Benny had struck him in the head, that Benny grabbed him up while on the ground like a bear hug. And then that's when David calmed down, and then all three of them proceeded outside onto the porch. That's when David became upset again. That's when Benny and Shell mentioned that David punched Benny in the nose, the Bridger's nose 1 time, and then David punched Michelle in her head 4 times, approximately 4 times.
Okay. And when you made this, were you able to locate a suspect? Okay, that individual that you observed at that location, do you see him in the courtroom today? Can you please point to that individual and point out an article of clothing?
The record can reflect he's identified by client.
Thank you.
Okay. And what did you do when you observed the potential suspect at that location?
Me and my fellow officer, Officer McGregor, called him to us, which we first asked him to lay on the ground and put his hands to the side. He did not comply to that, but he did walk over to us, and that's when we took him into custody.
Okay. No further questions.
Mr. Jones.
Thank you. How are you?
Good, sir. How are you?
Just living the dream thing. So I have a couple of questions for you. Should I have it? Why don't you describe, let's start with this. Why don't you describe for Judge Oakley what my client looked like when he encountered me?
So I noticed that he had multiple injuries to his head. We observed him to be very bloody, from the top of his head to the back of his head.
Okay. I sent you an email of some pictures, correct?
Correct.
And you had an opportunity to review them.
Correct.
And I trust you shared them with Borough Council?
I did not provide him.
Not that office. But he'll testify later. Anyway, so you saw the pictures, right?
Correct.
And in these pictures, my client's head was stapled shut, right?
Correct.
He had received in excess of 8 staples to his head as a result of Benny's, whatever it is that Benny did.
Correct.
Okay. Now, is it a fair statement that 2 wrongs don't make a right?
Yes.
Okay, is it also a fair statement that what you observed in the damage to my client violently exceeded what happened to either one of his parents?
Possibly.
Possibly. Did any of them require medical attention?
They both denied medical treatment.
I see. Did any of them require stitching or stapling, as you know?
Not to my awareness.
Okay. What about my client? Did he receive medical attention?
He did.
And a fair statement that you were involved in him receiving it?
I was on the scene for it, but I was not involved with providing the aid.
Alright. Well, I can do it a different way. Did you take my client into custody?
Correct.
Is it your understanding that while he remained in the custody of your police department, he was taken for medical treatment?
Correct.
Do you have any reason to believe that that was anything but absolutely and immediately necessary?
No, it's necessary.
Now, did you go into the home?
I did.
Did you see the shotgun?
Correct. Yes, I did.
Where was it?
It was in the living room.
Who was holding it?
Nobody was holding it. I was lying there.
Where were the 3 individuals who allegedly were involved in this incident?
When I arrived, all 3 were outside.
Was it communicated to you that they were afraid of being shot? They being, sorry, Judge.
Thank you.
They being Benny and Michelle.
They did not mention being shot.
Oh, they were afraid of being shot?
They mentioned being feared for their life, but they did not specifically say being shot.
Okay. Did you see anything in the house that would have created more fear of an immediate death besides the shotgun?
Not that I observed.
Okay. But Benny took the shotgun into custody to make sure no one could access it, right?
Benny, from what I know, Benny did not touch the gun.
Okay. Where's the gun stored?
Currently?
No.
I don't know who the gun was.
Who owns the gun?
Benny mentioned that David owns the gun.
Did you do any investigation to verify who owns the gun?
I personally did not. My sergeant Schultz is the one who spoke with Benny on the phone.
And did you know whether or not he followed?
I believe so.
And do you have any idea what he might have learned?
I do not.
Is she outside?
He does not.
That's a shame. Okay. You know the word. But we'll come back to that. All right. So, when you were told that Michelle was being held down, did you draw the conclusion that it was against her will?
I believe so.
And what did you understand was placed on her neck?
His forearm.
Just to be clear, his would be David?
David's forearm.
Thank you.
And no one said that the gun was in his hands at this point in time, right?
Correct.
So their testimony to you, albeit not under oath, was that he racked the shotgun, assaulted Michelle, but didn't use the gun to assault Michelle.
Correct.
And you never saw him with the gun, did you?
I did not.
And if I understood you correctly, you didn't do anything to verify that David owns the gun, did you?
Correct.
Did the gun get run for prints?
I do not believe so. I'm not sure.
Do you have anything you can share with us this afternoon that would indicate that David was ever in possession of it?
I do not.
How big is Benny?
Are you talking about height and weight wise?
Yeah.
I can't honestly do a detail right now. I don't want to provide the numbers up there.
Okay. Where's the stick that Benny said he hit my client with?
I believe it's still at the residence. It was photographed and left at the scene.
Do you know why it wouldn't have been taken into custody as potential evidence?
I'm not sure.
Where's the gun?
It was taken for evidence.
Was it your understanding that there was a battery done with the stick?
Yes,
And you saw this?
I did.
Can you describe it for us?
It was a yellow, long pole, used as an extender for painting. I observed the end to be some kind of metal. I don't know if it was aluminum or what, but
In looking at the stick, did you draw the conclusion that used as a weapon, it could do significant damage?
yes,
Consistent with what happened in my client's head?
yes.
Oh, good, thank you.
Redirect.
No, but
Officer, you can step down. Watch your step. Thank you. Didn't know if someone will stand. Didn't know show. Next witness.
Go for the witness.
I'm assuming you don't have any.
While normally that would be true, I think I want to see if I can learn a thing or two from the OIC.
Okay. That you? Okay, come on up.
Well, he was in the OIC chair, so
I just, sometimes they are, sometimes they aren't. Swear firm, tell the truth, all truth, nothing but the truth? Yes, sir. Settle in. When you're ready.
will you please tell the court?
Oh, I'm sorry. Put your name on.
John Bettendorf, Detective John Bettendorf from Van Buren Township.
I didn't get the back part.
With Van Buren Township Detective.
What capacity?
A detective. Thank you.
And what's your role in this case?
Just sent the warrant back downtown.
Okay. Did you do any investigation?
There was none to do, no. I just sent it down.
Did you review the evidence?
Just in the case file.
Did you ever interview any witnesses?
Not, no, sir.
Were you aware that the weapon was left at the scene?
Yeah.
Did a subsequent decision be made to take a look at that?
No.
Was anything done to determine ownership of the gun?
It's in the report, registered to all, the owner is David Disney.
And do you have any, did you ever, so you never went to the residence?
No, sir.
I got enough of them. Thank you.
No,
You can step down, John. Thanks. I'm ready for argument, fellas.
Judge, I believe that testimony reflects the question of fact. For the prior fact, I'm gonna reserve argument.
Mr. Jones.
Well, I think there's a question of fact, however, I don't think it would rise to assault the attempted to create bodily harm less than murder. Which I believe is the principal charge. Counsel?
Correct. Count one.
Yeah, the testimony was never that there was a fear of losing consciousness or a losing of consciousness. The testimony was that he didn't seem to have the gun in his hand, or that didn't cause the fear. So while politely and legally, I don't think there's a question about whether or not there was fear. I don't think the facts support the initial. I think the best was GBH.
Argument.
Judge, in regards to the GBH, I believe the testimony reflected the forearm was placed onto the victim's neck, and even though she didn't lose consciousness, I don't think she has to. So I think the testimony reflects that she had trouble breathing, which I think is sufficient enough for probable cause. Thus, I'd still move for a binding warrant all counts.
Mr. Jones, anything else?
Nothing to respond to both of them.
I don't know what blacks would say about the definition of the word suffocation, but trouble breathing would fit it for me. And I think that's all that's necessary for it to get downtown. I'm going to bind over on all counts. AOI date will be 2 weeks from today at 9 a.m. I will wish you gentlemen luck downtown. Bond is continued, gentlemen.
Yes.
All right. Thank you.
Thanks, Judge. Have a wonderful.
This courtroom proceeding quickly becomes tense as a defendant presents serious allegations against her own attorney. She asserts that her rights and privacy were violated, and her emotional remarks rapidly intensify the situation. As she continues to speak over the judge, the tension in the courtroom increases. The judge intervenes firmly, seeking to restore order and maintain control of the proceedings. Despite her repeated interruptions, the court makes it clear that proper courtroom conduct must be followed. This exchange clearly reflects the conflict between heightened emotion and judicial authority. Ultimately, the judge's composed yet firm response changes the overall tone of the courtroom.
You as well.
I have to have a word with Ms. Ortiz.
Hey, Mohammed, come here. Why were you so rough on Miss Farage?
What?
Why'd you give Miss Farage such a hard time?
But Judge, I'll talk to you at a later.
I'm a little, Brian.
Good to see you. Did you? I haven't seen him for a while.
If I didn't know you, you'd be the nicest guy I know.
But smooth. See how smooth he is? It's always so forced with you. Jonathan,
Yes.
he needs some sycophant lessons.
Why?
'Cause he's not as smooth as you. He's like a real,
Standard to compare somebody you love, right?
it's,
At least my understanding.
get to the ask.
I'm sorry. And I know it's a difficult situation, but my client is asking if there's any possibility that he could return home. I understand that is a huge request in a case like this. However,
Let me stop you right there. Is Miss Buchanan here?
she's not, I don't believe so.
The only way I consider is if I could talk to her. That's the only way I'll consider. I'll make myself available. We'll try to do something on Zoom if we need to. After I'm sure she's talked to the victim advocate and she tells me that she wants him to be able to come home, then I'll consider changing the bond.
What would be the best way for me to get that heard?
Talk to Heather.
Understood. Thank you.
Anything else?
No, Your Honor.
Goodbye.
Oh, I'm sorry, Judge, did we have it timed for the exam on the 23rd?
1:00.
Thank you.
All right.
People running on Stanley.
I'm sorry, Stanley?
Yes.
All right. Appearances, please.
Mohammed Abraham. He is.
Oh, hold on. That's Mr. Bickards. Go, that's all right.
Good. Yes.
Thank you, Judge.
Sorry about this.
Appearance on Stanley.
You have Mr. Stan. Should be in your Zoom room.
No, he should be here. It's a live exam.
Fair enough. That's absolutely true, Your Honor.
He's not
And
there.
he called me. He called me and I apologize, Your Honor, but he was the one that was literally just sending that ID to.
Okay.
He called, indicated that he thought he was supposed to be on Zoom. I know how that part works. I indicated that it's not.
Hold on. I got to cut you off. Was that 2 hours ago that somebody told him he was supposed to be here live? Because you and I had this conversation earlier today.
He had 1:30. Yes.
1:30. It's 3:20 and he lives in Romulus. He could have literally walked there by now.
We discussed that because I asked, I said, it doesn't sound like with that, because he said, look, I have no right. I said, sir, where are you at? I couldn't leave. Or as I may have actually been taken. It sounded like he was too far to walk, but again, I understand what the court is saying.
Too far for a lazy ass to walk.
I understand what the court is saying. I did ask Mr. Stanley to stay, to kind of stay put and stay by the phone, because at the time, Your Honor, and I will admit this was an hour ago, but there was an ongoing exam. I couldn't ask the court, and I couldn't ask Mr. Muhammad, and so I just told.
This ain't on you, Mr.
I
Bickards.
understand that, so I told him to hang tight. So that's
He
where we're
didn't
at.
do that.
That's
So you can tell him I'm issuing a bench warrant today.
that's where we're at. And that's that, Your Honor. Can I walk Mr. Stanley in?
Sure.
Do we need to do that on an exam day, or can that be any?
Any day he wants to get the warrant off his back,
Oh,
because there's a warrant on his back.
I anticipate that the court will see Mr. Stanley very, very
Good, because I've got a few things I'd like to share with him.
understood. So with that being said, Your Honor.
Have a nice day. You can tell him it's a 10,000 cash. Are you ready, Mr. Jones?
Of course, Judge.
Who's prosecuting? Is that you, Disney? Are you ready?
Most popular guy in Romulus for you.
Today he was. All right, gentlemen, your appearance for the people versus David Disney.
Your Honor, Mohammed on behalf of the people, PH 6771.
Let me wish a wonderful afternoon to you and your unparalleled staff, as well as my brother. My name is John.
Okay. All right, counsel, I've got two files. I've got a drinking and driving file from April of last year, and then I've got the domestic violence that she was just sentenced on, which is what we're here for on the bond violation.
All right, if she was sentenced, I guess I'm kind of confused as to how it would be a bond.
Yeah, I just sentenced her on this domestic violence should say it's a probation violation.
Okay.
She was just sentenced on the 17th, allowed to go back to mom's house, and said no, the condition was no assaultive contact. And from the police report I've seen, it looks like the allegation is that she went back and did exactly that.
No, my mom attacked me.
Don't speak. You got an attorney to represent you, Ms. Shimmer. You don't want to talk right now. So, counsel, I'm thinking I better set it for a violation hearing as soon as we can get one.
That's correct, Your Honor.
All right. Ruthie, I didn't think of this until just a second ago, so I probably need to get Emily involved.
You want me to pull her in?
Yeah, or just have her call me in the courtroom. Either way.
Okay. I think she's around, so let me just go see if she can come.
That's fine. Yeah. Tell her to bring her calendar.
All right. One with Emily now.
Ms. Trolley,
Yes, Your Honor.
on Miss Shimmery, I think we've got to set up a bond violation or show cause for a probation violation.
Okay.
So she's currently in custody, so I don't want to wait too long. Any reason why we couldn't do this? Squeeze this in for Monday morning? I've got video
Morning,
arraignments and I've got a violation docket with Huron, so we should be able to squeeze it in.
Okay, that will work. What time?
To the attorney.
Van Buren, we're going to need her here live. So if it's Monday morning, or if she's not able to post bond, are you going to be able to hold her and bring her in Monday morning?
She would go to the county if she wouldn't be able to post today.
Please talk to me.
You guys can't hold her till Monday?
Please.
I could request from a supervisor if would be able to
If we
accommodate
send her
you.
down there, we might not be able to get the paperwork down to them and get her back out here again.
Okay.
Emily, let's set it for. Oh, you've already got a violation on here, Ruthie.
Sir, we trying to remove.
Yeah, you've already.
Violation date for
I didn't
next
see
month.
the ROA. You've already got it set for Monday at 8:30, right?
Oh,
Let
let me take a look. Yeah, so Carol just scheduled it at 11. Oh no, this is for.
Yeah, April 23rd, 8:30.
Please, can I?
Okay.
You can ask.
Is this
All right.
the domestic violence case?
Yes.
Sorry? Can I please
have
speak
that
to
on
my
here.
attorney?
I think it's just on the blue ROA for now.
Yeah, that's fine. So that's when we're going to talk to her on this one.
Okay, what date is that?
Monday at 8:30.
Okay,
All right, Mr. Westmoreland, let's talk about bond on this file.
Yes, Your Honor. Ms. Shimmery did assure me she would be appearing at all future court dates. She was under the impression that she was allowed back to the home. I don't think that's what's in question.
Well,
But
I distinctly told her she was allowed to go back to the home, but if there were further problems and she was at fault,
I
then that
didn't
was
do
a
anything.
violation of her delayed sentence. So now we have to determine who was at fault.
Right.
I want Mark's honey, please.
Ms. Shimmery, I'm not going to tell
you're
you
going to
one
stand
more
muted
time.
this time.
One more time. Don't speak because you might hurt yourself by what you tell me. You've got an attorney to represent you now. Let him talk. Go ahead, counsel.
Your Honor,
There it is, the decision that changes everything. Bind over means this case is moving forward to a higher court. The judge believes there's enough evidence to keep this alive. Not guilt, but definitely not innocence either. And now, the stakes just got higher. What started as a chaotic courtroom moment is now turning into a full-blown legal battle. So ask yourself, based on what you've seen, how do you think this ends?